If you or someone you care about is facing a federal drug conspiracy charge, you need to understand how the sentencing actually works, because that is where the real fight takes place. I'm Michael Lowe, a criminal defense attorney in Dallas, Texas. I've been defending federal drug cases for over 2 decades, and I can tell you that the sentencing computation in a conspiracy to distribute case is one of the most complex and high-stakes processes in all of criminal law. Today, I'm going to walk you through how the federal sentencing guidelines apply in these cases, what changed under the First Step Act, how safety valve works, and where the defense can fight to bring that sentence down. Let's get into it. First, let's talk about what a federal drug conspiracy charge actually is. Under 21 U.S.C. Section 846, it is a federal crime for 2 or more people to agree to commit any drug offense under the Controlled Substances Act. That includes manufacturing, distributing, or possessing with intent to distribute a controlled substance. Here's what catches most people off guard. The conspiracy charge does not require that any drugs were actually delivered. The agreement itself is the crime. And unlike the general federal conspiracy statute, drug conspiracy does not even require an overt act. Prosecutors don't have to prove you did anything beyond agreeing to participate. This is why federal prosecutors add a conspiracy charge to virtually every multi-defendant drug case. It expands the scope of evidence they can use against each defendant. And under what's called the Pinkerton Doctrine, it makes each conspirator liable for the reasonably foreseeable acts of every other conspirator. So if you were a minor player in a larger operation, you can still be held responsible for the full quantity of the drugs involved in the entire conspiracy. That's how the government builds these cases, and it's something every defendant needs to understand. Now let's talk about mandatory minimum sentences, because these are the statutory floor set by Congress under 21 U.S.C. 841B. These mandatory minimums are triggered by the type and quantity of drugs involved. For example, a conspiracy involving 5 kilograms or more of cocaine or 1 kilogram or more of heroin carries a mandatory minimum of 10 years in prison and a maximum of life. Smaller but still significant quantities carry a 5-year mandatory minimum. And if you have prior qualifying drug convictions, those minimums go up. Now, the First Step Act of 2018 made important changes. Under the old law, 1 prior felony drug offense bumped the mandatory minimum to 20 years. The First Step Act reduced that down to 15. 2 or more prior qualifying convictions used to mean mandatory life sentence. The First Step Act brought that down to 25 years. The act also narrowed what counts as a qualifying prior conviction. It now has to be a serious drug felony or serious violent felony with a maximum sentence of 10 years or more, and the defendant must have been released from prison within 15 years of the current offense. On top of that, the First Step Act eliminated what's called stacking under Section 924C. Previously, prosecutors could charge multiple firearm offenses in the same case and stack consecutive 25-year mandatory minimums. Now, that enhanced penalty only applies when the defendant has a prior final firearms conviction from a separate case. These were meaningful reforms, and they apply to every drug conspiracy case sentenced after the act took place in December of 2018. One of the most important tools available to the defense in a drug conspiracy case is federal safety valve. This is a provision under 18 U.S.C. 3553F that allows a judge to sentence below the mandatory minimum when the defendant meets certain criteria. Before the First Step Act, the safety valve was extremely restrictive. You could only qualify if you had no more than 1 criminal history point, which meant almost any prior felony conviction would disqualify you. The First Step Act expanded this significantly. Under the current law, a defendant can qualify for safety valve if they meet 5 conditions. First, their criminal history cannot include more than 4 criminal history points, excluding 1-point offenses, and they cannot have a prior 3-point offense or a prior 2-point violent offense. Second, the defendant did not use violence or possess a firearm in connection with the offense. Third, no one died or suffered serious bodily injury. Fourth, the defendant was not a leader, organizer, manager, or supervisor in the offense. And fifth, no later than the sentencing hearing, the defendant must truthfully provide the government with all information and evidence they have concerning the offense and all offenses that were part of the same course of conduct or common scheme or plan. This is where defendants get confused, so I want to go deeper here. First, people underestimate what they have to disclose about themselves. The rule is not limited to the count of conviction. It covers relevant conduct, meaning the entire scheme. That includes uncharged transactions, drug quantities the government never found, and every part of the operation the defendant personally participated in. Hold back on your own relevant conduct because you think it's outside of the offense, and you lose that safety valve. Second, and this is critical, the statute only requires disclosure of the defendant's own conduct. It does not require the defendant to become a snitch. It does not require them to name co-conspirators, identify suppliers, or give up information about anyone else, indicted or not. Safety valve is not cooperation. Safety valve is not a 5K1. Under 5K1, the defendant provides substantial assistance against other people and the government files a motion for a reduced sentence. Under safety valve, the defendant simply comes clean about what they did and the judge can grant relief even if the prosecutor objects. So the fifth prong requires a full and truthful accounting of the defendant's own conduct. It does not require testifying against anyone, wearing a wire, or identifying any other participants. A defendant can qualify for safety valve and still keep their mouth shut about everyone else in the case. Now, I have to mention the Supreme Court's decision in Pulsifer versus United States, March 2024. The court ruled 6-3 that a defendant is disqualified from safety valve if they have any one of those three criminal history conditions I previously mentioned. Not all three combined, any single one. If you have even one prior 3-point offense, meaning a conviction that resulted in a sentence of 13 months or more, you are ineligible for safety valve, regardless of your overall criminal history score. That decision significantly narrowed the reach of the First Step Act's expansion, and it's something defense counsel needs to account for in every case. If the safety valve is not available, the other primary path to getting below the mandatory minimum is through a substantial assistance motion. This is when the federal prosecutor files a sealed motion with the court stating that the defendant provided valuable cooperation in the investigation or prosecution of other individuals. Only the prosecutor can file this motion. The defense cannot force it. In practice, this means the defendant cooperates with the government by providing truthful information about the criminal activities of others, and often by testifying against co-defendants. The degree of the sentence reduction depends on how significant and useful the information is to the government. Now, here's how the actual sentencing calculation works under the federal sentencing guidelines. The current guidelines are in the 2025 edition of the Federal Sentencing Guidelines Manual. While the guidelines are advisory since the Supreme Court's decision in U.S. versus Booker 2005, judges rely on them heavily, and most sentences fall within or close to the guideline range. The computation involves two main numbers: the total offense level and the criminal history category. Those two numbers are then plotted on the sentencing table to produce a recommended imprisonment range in months. The offense level starts with the base offense level, which in drug conspiracy cases is driven primarily by the quantity of drugs involved. The drug quantity table in the guidelines assigns a base level based on the type and weight of controlled substance. In a conspiracy case, the quantity attributed to a defendant can include all drugs that were part of the conspiracy and reasonably foreseeable to that defendant, even drugs they never personally touched. This is where the government often overreaches, and it's one of the most important areas for the defense to challenge. After the base level is set, specific offense characteristics can adjust it up or down. The most common enhancement in drug cases is possession of a dangerous weapon, usually a firearm, which adds 2 levels. Maintaining a premises for drug trafficking, what most people call a stash house, also adds 2 levels. Importing methamphetamine from outside the United States adds another 2 levels. And if the offense involved misrepresenting fentanyl as another drug, that is a 4-level enhancement. Violence, bribing law enforcement, or involving a minor in the offense can all drive the level up as well. On the other side, meeting the safety valve criteria gets you a 2-level decrease, and a mitigating role adjustment minimal or minor participant can reduce it by another 2 to 4 levels. Then criminal history is calculated. Prior sentences of imprisonment, whether you were on probation or parole when you committed the offense, prior violent offenses, all of these add criminal history points. Those points determine your criminal history category, from category 1 for defendants with no criminal history up to category 6 for the most extensive records. One important recent change, Amendment 821, effective November 2023, reduced status points from 2 to 1. Previously, committing an offense while on probation or supervised release added 2 points. Now it only adds 1. Another significant development is the 0-point offender adjustment under Section 4C 1.1 of the Guidelines, also effective November 2023. This provides a 2-level decrease for defendants with 0 criminal history points whose offense did not involve aggravating factors like violence, firearms, or a leadership role. According to the U.S. Sentencing Commission, drug trafficking was the second most common offense type where this adjustment was applied in fiscal year 2024. The Commission also made it retroactive, so defendants already serving time who would have qualified can petition for assistance regarding this reduction. If you're a first-time offender facing a drug conspiracy charge, this adjustment should absolutely be part of the defense strategy. Your role in the conspiracy can also significantly affect your sentence. Under the guidelines, if you are an organizer or leader of an operation involving 5 or more people, your offense level goes up by 4 levels. A manager or supervisor gets a 3-level increase. If you are a minimal participant, your offense level decreases by 4 levels. A minor participant gets a 2-level decrease. These role adjustments can shift the guideline range by years. So if you were a courier, a lookout, or played a minor role in a larger conspiracy, presenting evidence of your actual role is critical. The defense needs to show the court what you actually did, not what the indictment says everybody else did. At the sentencing hearing, the defense lawyer's job is to argue that the guideline calculation is too high and that the individual circumstances of the case warrant a lower sentence. Under 18 U.S.C. section 3553, the court can depart from the guidelines when it finds mitigating circumstances not adequately considered by the Sentencing Commission. This is where the defense presents evidence about who the defendant is as a person, their personal history, mental health, family situation, employment record, military service, anything that paints a complete picture beyond the charge itself. The drug quantity can also be challenged. The amount of drugs attributed to a defendant is often the single most important fact in the case. If the defense can show that the government's calculation is inflated or based on unreliable, cooperating witness testimony, the penalty range can come down a lot. Federal sentencing in a conspiracy to distribute case is complex, but there are real tools available to fight for a lower sentence. The safety valve, 0-point offender, role adjustments, challenging drug quantities, and presenting compelling mitigating evidence can all make a meaningful difference. If you or someone you know is facing federal drug conspiracy charges, I'm here to help. I'm Michael Lowe, a board-certified criminal defense attorney in Dallas. You can reach my office at 214-526-1900 for a free consultation.